Hello, this is the first session in our series of 4, and I'm going to start off by speaking to you about case preparation and saying a few words about pre-trial preparation and taking it right through to the importance of closing speeches. One of the key things that I'm going to say, and I will say a number of times, is that the key to prosecuting any case is really twofold. You've got to have a clear analysis of the evidence, but also you've got to have a clear idea of what you're going to say in terms of case theory. And the idea of the case theory is that it allows your case to come to life, and it allows you to present a case with some vigour to the tribunal. And really it's the foundation of all the case preparation and the flow of trial. You know, we have a phrase that we use. We say that the devil is in the detail, and really that's what this is all about. You will find that whenever you look at a case, you will master it if you are on top of the detail. The detail is absolutely critical. One thing I will say, and I'll come back to it later, is that although you need a mastery of the detail, you also need the ability to stand back once you've mastered that detail and to look at the key points in the case. But certainly there's no question about it, the detail is absolutely fundamental. I should just add this caveat as follows really, that of course as an English barrister I'm going to be speaking about English law and procedure. Now I know that we have an enormous amount in common in the sense of a history and the procedure that you follow in Nigeria. But I do recognise that of course there will be differences. So if I say something that doesn't really seem to strike a chord with you, well please forgive me. It will only be because I'm a product of the English legal system. I hope that nonetheless, if I do cover something that is not reflected in your system, that you will find it interesting nonetheless. So let's start at the very beginning. You're the prosecuting lawyer, the police have come to you, and the first thing you'll do is you'll read the case very carefully, and you'll be asked to review whether or not there is a case that should be brought, and you'll then be asked, if you come to the view that there is, what is the recommended charge? Now, the police may have a view, the police may well have charged the defendant already before they've actually come to you, though they may have instituted a charge. You need to look at the evidence and make sure that it's actually the correct charge. So in terms of selecting the correct charge, you need to look at the seriousness of the offence, you need to think about the sentencing powers of the court, and you need to think about the ability of the case to be presented clearly and understandably. So let's just break that down for a minute. The seriousness of the offence. I mean, if you've got, for example, an assault case, is it really going to be fully reflected by an assault charge which alleges actual bodily harm as opposed to what we would know as grievous bodily harm? It makes an enormous difference, and it will make a difference to the sentencing powers. Now, it's not our job as prosecutors to be vindictive in any way at all. Of course it's not. But nonetheless, there is a public interest resting on the shoulders of prosecutors to think about the sentencing powers of the court, to make sure that looking at the gravity of the case, that the court will have sufficient powers to deal with the case in the way in which the court thinks fit. And then also the ability of the case to be presented clearly and understandably. You really don't want your tribunal, whether it's a judge or whether it's a lay people, you really don't want them sitting there thinking, what is this about? And the charges will frame the way you present the case. So you want to think about that very carefully. Now, I want to say just a couple more words about that, because I think they may help you. You want to look at the heart of the criminality. Well, what has actually happened here? What's occurred? What is the centre of the criminality? Because that's what's got to be reflected in the charge. And you may find this is a case where you will want to make use of specimen charges. You don't want to overload the indictment. You may have a case where, for example, somebody has committed multiple offences and they may be of exactly the same sort. In that type of situation, you wouldn't, if somebody's, let's say, stolen property from a shop and done it 40 times, you're not going to want to put 40 offences on the charge sheet, because what will happen is the ability to present the case clearly will be lost. So think about the use of specimen charges. And then I've got one other thing to think about, which I think is important, and it's something that you will obviously gain in experience. Do think about the admissibility of evidence when you charge. It is something that prosecutors very often overlook, but they shouldn't do. You see, it's all very well having a focused criminal charge, and I'm not for one moment suggesting you shouldn't, but do think about what evidence you've got and whether that evidence is admissible to prove the charge. And you may well want to think about that line between conspiracy offences, the inchoate offences, and the substantive offences, because you will remember that the evidential scope to present material is going to be greater if you're going to allege an agreement to commit a crime rather than the crime itself. And so admissibility of evidence is actually a key factor to be thought about at the time when you're selecting your charge. Now, in England and Wales, the Crown Prosecution Service will use what is known as a full code test to determine whether a charge is satisfactory. And there are two questions in the test, and I'd suggest that they are sensible questions for every prosecutor to ask, even though they may not actually have a code like this applying. The first question is this: is there enough evidence in the case? Let's look at that. It's sometimes known as sufficiency of evidence. It's the first test. Is there sufficient evidence? You don't want to bring a case and lose it. Worst thing you can do is bring a case, lose it, and that sends out all the wrong messages to the criminal fraternity that they can get away with something. So we've got to make sure that the evidence is sufficient. If the evidence is lacking, don't hesitate to ask for more. If you're unable to find evidence, well, then whatever you do, recognize the reality of that position. It's essential to know what is missing as well as what you have. So you're undertaking an analysis of the evidence, the strength of the evidence, and what is missing from the evidence. And again, you want to think about that, because what is missing is what you will then ask the police to find. And if they can't find it, well, it's best to know now that it's impossible or unlikely to be obtained. So if in fact you are aware of evidential weaknesses, that's actually no bad thing, because it gives you an opportunity to fill them at an early opportunity, or not to waste any court time and expense in pursuing a case that can't be taken home. And so that's important. The test that you would ask, the question you would ask, typically, certainly in England and Wales, is to say, well, is there a realistic prospect of conviction? And that's the question. And so it's a difficult one. What does realistic prospect of conviction mean? We've had lots of discussions in this jurisdiction, in England and Wales, about what that means. Do you apply a percentage to that? Well, the truth is that most people would say, well, hold on a minute, percentages are difficult. What are you going to say? That there's a 60% prospect of conviction is realistic? I'd suggest to you that if you went down that road, that would be putting it too high. Do you want to say it's a 40% chance of conviction? Is that too low? What does realistic mean? It's very, very hard to see it in percentage terms. You might want to apply a sort of a balance of probability scenario. Say, well, is it likely that we're going to get a conviction? A lot of this, you know, is common sense at the end of the day. Because if it's likely we're going to get a conviction, we should run it. But if it's not likely, we shouldn't waste time. And so that really is how I would suggest you approach this test. Realistic. Is it realistic to think there will be a conviction in this case? If the answer is yes, go for it. If the answer is no, then don't. But that, of course, is subject to the second element here, the second test of the public interest. The second question you need to ask yourselves: is it in the public interest to proceed with the case? Now, there are many jurisdictions, let me say, where the public interest to proceed with the case is not really something that features in a big way. You can have jurisdictions where there's a zero-tolerance approach to prosecution. You commit a criminal offence and you will be prosecuted. Now, the common law tradition is really not to go down that road. The common law tradition is to actually say, well, again, hold on, we have significant discretion as prosecutors in whether to bring a case, even if there's sufficient evidence. Is it in the public interest? And what type of things do you consider? Well, there are many of them. I mean, of course, one of the things you'll look at is the sufficiency of evidence, because that, in a sense, does impact on the public interest. I mean, if there is overwhelming evidence, and so there's more than a realistic prospect, you can't possibly, looking at the case, see how there's going to be an acquittal. You may well say, well, that impacts on the public interest. You'll certainly look at the nature and the seriousness of the case, and you'll look in particular at, well, a number of things. Can I suggest you think about the prevalence of the offence? Sometimes there are situations where there is a particular form of misconduct and it really does need to be stopped. And you may well be saying, well, in that situation, as a matter of public interest, there's no scope for latitude here. The public interest militates in favour of prosecuting the case. You may say, looking at the case, that there are some particular mitigating circumstances, and in that situation you'll be going the other way. For example, you may have a defendant who is very seriously ill. We've all met these situations, have we not, where the defendant comes in with a doctor's report that tells you he has 3 months to live. Is it really in the public interest to prosecute that person? Well, it might be, notwithstanding. But equally, you might well take the view that it's not. It's going to be dependent on a whole cocktail of factors. You put them all into the melting pot, and you would say, well, we think this is or isn't in the public interest. And so these are the type of things you'll consider. And one of the things you will also consider, may I suggest, I hope it's helpful to say these things, is that in working with youths, you may want to consider carefully the opportunity for out-of-court disposals and the intervention of parents and the social services or community services, whether there's another way. You know, criminal prosecution is a very blunt experience. Criminal process is a very blunt experience, and it is, we should recognise it is quite alienating. What we do is we pit the power of the state against the power of the individual, which of course is much less, it's quite a brutish thing that is taking place. That's not to say it shouldn't occur, because there are many cases where, of course, it's necessary. We'd have anarchy if we didn't have prosecution of criminality in the courts. But when we're dealing with youths who do not have a criminal record, let's just pause. Part of the public interest, let's try and avoid stigmatization if possible, because if a youth is prosecuted and convicted, then of course that will have consequences for the youth in seeking employment, in looking towards their future. Now, that's not to say that there are not cases where you won't prosecute youths. Of course there are, and I'm not suggesting that. All I am saying is that in looking at the various factors you want to take into account, you may want to think about that too. It's a relevant factor, I would suggest respectfully, when thinking about the public interest. Okay, just a few words then on charging. Now let's move on. What about case preparation and managing delays? Very difficult, we know. You'll be working very closely with the police to prepare their files, and that involves a striking of a balance between the professional relationship with the police and your autonomy as a prosecutor. You're not there to take orders from the police, but you are there to have a close working relationship with the police. But of course you stand one step aside from them. That shows in a particularly important way with disclosure of unused material. Do be careful here. We've had some terrible experiences over the years in the United Kingdom, and certainly in England and Wales, with the duty to disclose and failures to disclose evidence. And sometimes, of course, it can be malign. I'm sorry to say that, but we have had cases, thankfully very rare, where our police officers have not been as careful and as proper as they should have been. But very often when a case fails through lack of disclosure of unused material, very often it's simply done through negligence or mistake, and it can be quite innocuous, but of course so damaging if material that the defence should have is not disclosed. So do think about that, and think about your duty to review the evidence for disclosure. And again, if there's material that you think you should have expected there to be in the file, it will be worth asking about it. Because you can be sure of this, if you don't ask, the defence will, and it's better for you to find out. Give you an example. You may be looking at the papers and thinking, oh, very interesting, but how did the police discover this? I think you're entitled to know that. I think that could be a very relevant matter. Now, it may be that that is sensitive material, and you want to think about that, but you need to see it, and you need to assess it, and you need to consider on an ongoing basis whether or not it is material that will need to be disclosed. And if it is material that's relevant, you may need to seek judicial guidance on how to handle that, and whether it should or shouldn't be disclosed. And of course, in the ultimate case, you may have a decision to make if you do find you're in a situation where sensitive material needs to be disclosed, but you really can't disclose it for public or policy reasons. Well, then you're going to have to think about the viability of the prosecution, and that takes you back to the public interest factor that goes into the charging equation. With sensitive material, do try and encourage your police officers not to copy the material repeatedly, either physically or electronically. I've seen a number of cases where sensitive material is put in the hands of investigating officers, and very often for a very good reason, because they need to know what's gone on. But do they actually need to have copies of that material, either in their electronic files or their physical files? The answer very often is no, they don't. And of course that means that if material does get into those files, the scope for accidental disclosure of sensitive material is significantly increased. And so you want to avoid that. Try and guard against the accidental disclosure of sensitive material. And that can happen either electronically or physically. The other thing to bear in mind where you will want some assistance from your technical support is, of course, the copying of files. You need to be very careful, even today with our wonderful technology, that when files are copied, they're not corrupted. And you, as a prosecutor, you want to look out for this and make sure that that hasn't happened. How often do you have a situation yourselves, maybe, where you save a document, or a document gets copied over, and you realise the provenance of it is changed, that the date it was created has suddenly changed to the date it was copied. Things like that you need to be careful of, is that bring a case down if it's not spotted and not dealt with, and really you need to guard against it. So you've got all these things to think about in terms of case management. And then the issue of delay. Well, delays do happen, but you do need to sit on top of this. Prepare a timetable, a case timetable, keep the court and the defence updated, and keep a strong eye on what's going on. Now, I said I was going to say a few words about case theory, and I think this is the point where I will begin on that journey. You do need a case theory. I suggest it's important. You want to get the issues in a case simplified and clear. One way of doing it is to actually just look at the case and say, can I explain what has happened in 2 or 3 sentences? Try and work out what those sentences are. Identify what the issues in the case are, what's actually happened, and look at the elements of the offence and develop that very short summary. You need to need to have a succinct understanding of what has happened, and a succinct understanding of why it has happened. And if you have those 2 things, they will lead you to a short, succinct, clear, unambiguous case theory. And a theory, we talk about theory. In a way, it's a word that worries me. It's something that's crept in recent years as being a way to describe and to explain to people how they should approach things. But really, you do need to be a little bit careful. We're not talking about case supposition. We're not talking about case hypothesis. We're talking about understanding how we're going to prove the case. And that's what's important. Once the issues are identified, you then ask the next question. What do I need to prove? And so that's taking us back to the original assessment, which is to look at the evidence. And here, now, once we've got the case underway, we really want to drill down on that evidence. And it's not simply reviewing each witness and the exhibits and determining whether or not, looking at the offences we've decided to charge, whether they address those issues. That, of course, is important, and that all goes into the question of how you're going to produce the case. But can I suggest you think about another aspect which trips prosecutors up time and time again? And so I'd add this as an additional point. Do think about the provenance of evidence and the issue of continuity. It's all very well for witnesses to produce material, but where does it come from? Where's it being kept? Has it been in continuous review and kept safely? Is there any scope for contamination? Is there any scope for a break in the chain of continuity? Because if there is, you know the point that the defence are going to pick up on. They'll be there immediately. And so you need to make sure that you cover this. And you may need to have sometimes a multiplicity of witness statements to say that this document was found in this place and it was handed to this officer and then it went to the next officer and then it was reviewed by a detective and then it was sent off for analysis and then it was brought from analysis back to the police safe and then it was got out from the police safe to be put into evidence. You will need to have all of that evidence because you can't be sure that your defendant is going to make any admissions at all about that sort of thing. In fact, quite the opposite. You must work on the supposition that the defence will be looking to prod at any opportunity to see if they can find a hole in your case. Now, the opening speech. Let's say a few words about the opening speech. So you've got a few notes that we've circulated for you. Don't want the opening to be too long. You don't want the fact-finding tribunal to fall asleep, and you want them to understand and follow the issues, and they need to have that in immediate grasp. You also need to have a little bit of room for manoeuvre for your witnesses to give their evidence without being pigeonholed by your opening remarks. Let me express it in this way. Do not over-prosecute a case in the opening. Witnesses may not come up to proof. Do not make any assertions that you really are not sure that you will be able to prove. Keep it factual. Keep the temperature down in opening. It also means that, so far as the fact tribunal is concerned, you're not going to disappoint them. They're only going to get more interested with some of the more beefy, juicy bits come out. But what you don't want to do is have them waiting for something that sounds interesting and then never appears. So confine your opening. Keep it short. Keep it brief. Who did it? What happened? When did it happen? Where did it happen? Why did it happen? And then a brief description. The prosecution is going to call this witness to say this and this witness to say that, but keep it short. This is where the case theory, of course, dovetails with what we are now doing in practice. That, I would suggest, is important. Don't be too strong in asking the jury how they should handle, or the fact-finding tribunal, how they should handle the evidence. I must tell you, I've had many years of experience initially as a prosecutor. I'm not going to mislead you. I haven't prosecuted, not really, not big time, since taking Silk. But I did a lot of prosecution work before taking Silk, and I always tried to lead the fact-finding tribunal, whether they were magistrates or juries, was try to lead them to a conclusion. But you know, in opening the case and in closing the case as a prosecutor, I actually never said to them, you must find this defendant guilty. Now, I know that you'll see that on television, but I would always do it a little more gently. And members of the jury, you may find, when you look at all the evidence, it is a matter for you, but you may find there's only one conclusion you could reach. And that would be it. I wouldn't say, and that conclusion is that the man's guilty and that there's no way in which you could acquit him. Don't go too heavy. Don't go too heavy. Wear the prosecution cloak lightly, and you will get better results. Of course, it's entirely different when you're defending. You will say, if you're defending, members of the jury, you've heard the prosecution case is riddled with holes. How could you possibly convict a man on this? And so you would take a completely different view. But wear the cloak of prosecution lightly, and you will get better results. If the case is straightforward, don't be alarmed if it's only a few minutes in the opening. I mean, cases can vary from a few minutes to a week, depending on the complexity of it. I've certainly opened cases where it's taken me 3-4 days to do that. It can be quite tiring. But the length of the opening is going to be fact specific. And so do bear these things in mind. You may want to mention, I'm not a great fan of showing the fact-finding tribunal lots of documents in an opening speech. You'll want to signpost, of course, the key evidence, but really I would go to the documents that are really incontrovertible, and I'd use those, but I wouldn't do more than is necessary. And I think that's what I'm trying to say to you. Don't do more than is necessary in opening the case. Handling witnesses, well, say immediately that witnesses with vulnerabilities require different and specific care, and you're going to hear some experts who are going to tell you about handling witnesses who are vulnerable in the coming weeks, and I'm not going to trespass on that. I'm not going to do that. I think what I will say to you, though, if I may, is this, that in a sense almost every witness is vulnerable. Well, perhaps not the professional witnesses, but the lay witnesses. You know, witnesses are vulnerable, even if they're not technically vulnerable in the sense that you're going to hear about. Witnesses are nervous, they're worried, they're out of their normal situation, they're unsure of what is required of them, they're unsure of the criminal system. You do need to go carefully, go gently with them, introduce yourself to the witness, explain your role as prosecutor. It's so easy to forget in the hurly-burly of prosecuting a case. You turn around to your police officer and say, "Is Smith here?" "Ah, yeah, thank you, Mr. Smith. Thank you for coming. You'll be on in, about 10 minutes. And off you go. And it's understandable. You go in, but you carry on, you go into court, and you think no more of it. Who's actually said to Mr. Smith, what's your role? Who's going to be asking questions? In what order? About the layout of the court. Where's Mr. Smith going to be standing? How's he going to be asked questions from other people, from the judge, from the defence counsel? And so you need to have that introductory chat. Now, don't review the evidence with the witness. That's not going to be allowed. It's not for you to rehearse your evidence. So there's a clear line. Don't cross it. Don't hold a mock examination in chief. You don't want to be subject to some allegation that you've coached a witness. So there's a line. Courtesy, explain the position, informative, but don't delve into the evidence, and be understanding of witnesses who do have that level of nervousness. And also, you want to ask the witnesses, just check out with them whether or not you think there are any further orders that may need to be obtained. There may be compensation, there may be restraining orders, there are all sorts of things. Just have those in the back of your mind. And the other thing to just be aware, and it does happen, and it happens more often than I think people realise, the witness will say something which you haven't necessarily initiated, but it's information that's important for the defence to know. And it just comes out in the course of discussion. And sometimes they'll say to you, we ought to mention to you. Just make a note of what they mention. It's important. It can go to the heart of the case. And so if they do mention facts, for example, not been mentioned before, or they say something that puts a different complexion on what they've said before, note it down, and you do need to disclose it. And so that's got to be done. You may well be in a situation where you'll be asked for a further witness statement, and have it all done in that way. But you need to think about those things as well. A witness may not attend for a variety of reasons, and of course one of the reasons we've got added to now is that they may be in quarantine through COVID. But look, failing to attend by a witness is of course not an automatic reason to offer no evidence. But you do need to think, when you know a witness is not going to come, just think about the value of that evidence, the importance of it to the prosecution, and also think about the importance of it to the defence. The general sort of approach on the whole is to try and avoid adjournments. They add to the anxiety of other witnesses, they add to the anxiety of the defendant, they cost a lot of money. But sometimes you'll be in a situation where you have to ask for an adjournment, or you recognise the defence will ask for an adjournment, and just take a realistic view. Again, it's something I think I will say to you that I hope is coming through my level of remarks. You want to gain the confidence of the court. You gain the confidence of the court by being straightforward, by being pretty honest, by not mucking around, by being realistic. And I would suggest that here is a place for a dose of realism. If you don't need the adjournment, press on. Be open about it. If the defence you recognise will need this witness, recognise it. Don't oppose something just for the sake of it, just because you're there as the other side. The court will trust you much more on other things if they know that you're the sort of advocate that is not going to take bad points. Take the good points, don't take the bad points. And so I think that is something that comes into play here when we talk about asking for an adjournment. I mean, of course, there are all sorts of other things you'll want to think about, for example, why the witness has not attended, what inquiries are being made, you're going to ask the police to assist, and so on. But yes, these are things that you may want to think about. They're all important. As I say, don't forget the position of the defence. Of course, when you're dealing with police officers, slightly different, isn't it? Because they are professional witnesses, so different to calling a civilian witness. You need to obviously, of course, identify the officer and the officer's experience. You just be careful here. If you're going to get the police officer to give you an expert view, for example, I know I can say that in my experience that driver was driving at 35 miles an hour in a 20 mile an hour speed limit. Well, on what basis does he say that? What's his experience as a road traffic officer? How has he been able to assess the speed? You need to lay the foundation if you're going to get any expert evidence. Very often it's better, if at all possible, to confine the witness, the police officers, to witnesses of fact. Occasionally, of course, you'll have a situation where a witness, not a police witness obviously, but where a civilian witness turns hostile, where the witness it does not come up to proof, does not say what they said they were going to say in the witness statement, and is quite clearly somebody who is being obstructive to the prosecution case. Again, be slow to treat them as hostile. You realise you have to, I know you realise you have to apply to the court, at least you certainly, that's the position in England and Wales, to treat a witness. I don't think, well actually strictly, whether it is the position in England or Wales is another matter, but you certainly wouldn't, as a matter of course, treat a witness as hostile unless you really had to. If you do, you'll be putting their witness statement to them, and you'll effectively be cross-examining them. But there we are. These things do happen. Now, when you're designing how you're going to examine a witness in chief, and I would suggest this is true of your civilian witnesses as well as your police witnesses, come back to the case theory again, come back to the key points that you want to develop, and do break your questions down into sections. Build it up slowly, foundational steps, short, simple, open questions. Take it slowly. Don't pressurize the witness. Don't push the witness into closed questions. Of course, you can't ask in the examination in chief leading questions. Leading question is not actually a closed question. But the thing about closed questions is that they don't have the same force in terms of evidential impact. Much better to lead the witness slowly, surely, with open questions, and do listen to what the witness says. It's very easy. I mean, we all do it. We've all done it, where you're thinking of the next question you're going to ask at the time when the witness is asking the question you last asked. And so, you've got to multitask. Do listen to what the witness is actually saying, and make sure that you're getting from the witness exactly what you want to get from them. And that's why you need to have a clear idea in your mind, have a note of the particular points that you really want that witness to cover. And in cross-examination, of course, goes the other way. Now, you've got enormous scope when cross-examining a defendant as to how to do it. I suggest there are completely different approaches that you would take to approach the defendant and the defence witness. I mean, certainly if a defence witness is a character witness, I think you would go very gently and work out what you want to ask, if anything. I mean, you may not want to ask a defence character witness anything at all. Cross-examining the defendant, of course, is a different story. You might choose, there are a number of ways of doing it. You could go for the jugular. And this is a perfectly respectable way of cross-examining if in appropriate cases. You may want to do the opposite and absolutely lavish the defendant with kindness and politeness. You may, as a third option, want to be firm and to the point and deal with something chronologically. I think you need to look at your case. You need to look at your case theory, you need to look at your defendant, and you need to make a decision as to how you're going to do it. Go for the jugular if you think that the best way of doing this is to get your defendant annoyed. He's somebody who's being prosecuted for road rage, so you might well want to stand up there. First question, well, Mr. Bloggs, do you think you've got a temper? And so on. You might want to do it differently. You might want to kill them with kindness. Well, Mr. Bloggs, I hope you don't mind, but I've got a few questions to ask you, and let's start by taking some of the more. Let's see what common ground we can have. Now, do you agree it's Tuesday? Thank you. And can we agree that at this moment in time it's 1 o'clock and we're now going to break for lunch? You're trying to get you want the defendant to relax. You're leading them. You're plainly going to lead them into a trap, but you want to get information from them. You want to wrap them in knots. You're not going to wrap them in knots if you've gone for the jugular. Mr. Bloggs, you know why you're here. It's because you're a murderer. You can't have it both ways. So you've got to work out what's going to work for you. I mean, the third option is to just go through things chronologically and just poke at them and see what you get. But I must say, my instinct, each case is going to be different. Because I've sort of tend to do so much fraud work, historically my approach has been to kill people with kindness, so that by the time they're finished in the witness box, they don't even realise what you've done to them, that you've absolutely massacred them, but they have no idea. And that is an approach that works very neatly in fraud cases. But in violence cases, it might be different. So I do say to you that you need to think carefully about your plan. Have a clear plan in cross-examination. What is the purpose of the cross-examination? Is it to elicit favourable new information? If it is, you're going to want to kill them with kindness. Is it to obtain contradictions with other witnesses? Well, yes, I think it is the same. If it's to establish a motive for lying, more difficult. If it's simply to put your case and confront the defendant, then of course you'll be taking a different view. So I urge you, this is one of the most difficult areas. You're not required when you cross-examine to use those, I suggest they're awful phrases. I put it to you. I've always tried to avoid that sort of stuff. I suggest, just put the case. I mean, Mr. Bloggs, I'm sorry. I know you say you were there, but the evidence is clear. You weren't there. What do you say to that? Yes, use techniques like that. I suggest that they're very, very helpful. So all these things are useful. There are all sorts of other things you want to think about. I mean, previous convictions. You're going to use them? You're going to try and use them? What are you using them for? What's the purpose? Think about that. So go back to your case plan. Are you trying to suggest propensity? Are you trying to suggest lack of credibility? Think about it. Maybe neither. If neither, why refer to the convictions? But if it's just pure prejudice, well, no. I mean, plainly not. That's what I mean about having the trust of the tribunal. What about your closing speech? I've got a few thoughts there, and then we'll wrap up. The closing speech is the opportunity to highlight the strengths of your case, obviously, and to reframe weaknesses. And we've all done cases where we've had to do a bit of tidying up, where witnesses have not said what we want them to. I know that some of my colleagues will write their closing speech before preparing their questions. I must tell you, it's not something I've ever done. I rather think that the closing speech has got to be flexible. You've got to be, swift on your feet. That's what the advocacy is about. And so you don't get, although I've hammered on a bit about case plans, don't get too constricted by them if something has moved. So I think a little bit of elasticity in your closing speech can be very useful. But yes, it is the time to highlight the strength of the case, because you are going to be effectively inviting, even if you don't use this language, of course, the subtext is that the person's guilty, and that's what you've been doing. I think you need 3 or 4 killer points, and I'm just going to say a bit more. I know that you'll be very familiar with the things you must do, the standard of proof, the elements of the case, the points of law. You'll cover all of that. You'll anticipate what the judge is going to say. It's always a bit nifty. Don't overdo it, but to say 1 or 2 things that the judge is going to reiterate, and is going to be uncontroversial. Again, it's a good way of having a rapport with the judge of the fact-finding tribunal, who you should always look at, by the way. Best have a conversation with them. Don't harangue them. Don't harangue your tribunal. Speak to them. They're human. Try and engage them. Eye contact. Smile occasionally. The appropriate. Don't come over as an inane fool, but try and have a rapport with them. And 3 or 4 killer points. So what do I really mean by that? I started off by saying to you, master the detail. I don't retract from that one bit. Cases are won or lost on the detail. But you've got to work out, once you've got the detail, what are the killer points from within the detail. So I suggest to you that you take your best 3 or 4 points. And that's what you hammer home in your closing speech. If you can't get your best 3 or 4 points home, if you can't convince the fact-finding tribunal on your best points, you're not going to convince them on your worst ones. So don't waste their time. A lot of this is judgment, and work out what are those killer points, and then make them. So I think we're probably coming up to a point where I should wind up, I think. Otherwise, typical of any barrister, you can speak for hours and hours, and you don't want me to do that. So I think I'd really say this to you, and I hope it's useful. Number one, have a case plan. Number two, focus on the key ingredients you have to prove. Number three, look at the evidence, identify what your key evidence is. Number four, work out your killer points and stick with them. Number five, resist over prosecution. And I do think that that's important. So I hope this is of use to you. I'm sure that I've said a lot that you know already, and I appreciate that. It's a question. We have an expression of teaching mothers to suck eggs. I don't certainly hope I've avoided that. I've certainly tried to remember that you are very experienced, and I hope that maybe if I've just said one or two things that may be of assistance to you, then the process and our contribution has been worthwhile. Anyway, there we are. I'm going to leave it there, and we're going to meet later on and in future weeks. So thank you very much. Thank you for tuning in.